Supreme Court has ruled as unconstitutional the decision to pay the spouses of the president and vice presidents of the land, saying it is inconsistent with Ghana's 1992 constitution. Now, this case was brought before the Apex Court by MPP's Bono Regional Chairman Kwame Bafo, popularly known as Abronye. He sought 4 reliefs, but 3 of them were granted. My colleague Richard Kojonyako is here with me to take us through the 3 cases that were upheld by the Supreme Court and the one that was quashed. Richard, tell us about it.
One, on the declaration that per Article 71(1) and 2, the positions of the first and second ladies of the Republic do not fall under the categories of public office holders. You know, this became a very, very huge issue in the country. The second one is that the declaration that the approval of Parliament to pay salaries to the first and second ladies is inconsistent with Article 71 clauses 1 and 2 of the 1992 Constitution of the Republic of Ghana, and consequently be declared null and void. And the last one that was granted by the Supreme Court was that the declaration per Article 71 of the 1992 Constitution of the Republic of Ghana, the Emolument Committee is limited to recommending the salaries and other benefits and privileges of only public office holders. So it stands to reason that if you are not a public service or a public office holder, then you cannot qualify to be paid the emolument that are paid deputy ministers, ministers of state, and other people that fall under Article 71. So that essentially, that is what this decision by the Supreme Court mean. But you know, there is one more relief that was not granted by the Supreme Court, and it's the declaration that per Articles 108 and 178 of the 1992 Constitution of the Republic of Ghana, Parliament cannot on its own accord, initiate or approve payment of any such emolument which would necessarily be paid from public funds without a bill to that effect emanating from and introduced by the government and duly passed into law. And so this was not granted by the Apex Court.
Right. Thank you very much. And let's listen to the man who brought the case to court himself, Kwame Bafo, aka Abronye, and his lawyer.
I was surprised to hear that Parliament has adopted the recommendation that first and second ladies should be added to the position as if they are the deputy ministers. That is why I filed the suit, and hopefully the Supreme Court has said that Parliament exceeded their jurisdiction. They don't have that mandate to add unless that particular provision, which is an intent provision, be amended. And it's something that we have to amend it through referendum, and Parliament cannot do that unless it's done through referendum. So that is why the Supreme Court set aside the entire decision by Parliament that first and second ladies should be paid by the taxpayers' money. I think it's unconstitutional.
So we brought this instance action to invoke the original jurisdiction of the court to strike out certain acts that Parliament in seeking to pay salaries to the first and second ladies of the land. And thankfully today, save for relief 5, all reliefs have been granted. And for me, I'm happy, not just because I was the counsel who came before the Honorable Court, but also the fact that I'm a citizen of the Republic and the rule of law has been upheld in this instance case again. That is also giving us the assurance that the Constitution is still in force and it's been upheld by the judiciary, and I'm very, very happy very much about that.